So we definitely are very honored to have you speak with us today on this webinar. It'll be our last webinar in the Great Legal Minds webinar series for this year. So for everyone that doesn't know, the famous Francis Carter, he is a full-time mediator in Miami, in the Fort Lauderdale area. And wow, he's mediated more than 1,000 commercial, civil, and bankruptcy cases. Anything from contract, landlord, tenant, debtor, creditor, commercial fraud, business dissolution, and even international business disputes. He's a graduate of UPenn, and he received his JD at the University of Virginia Law School. He is a fellow of the American College of Bankruptcy, and it has been included in the best lawyers in America since 1991. He is also a settlement counselor, serving as an advocate or consultant to assist litigation counsels in formulating settlement strategies and conducting settlement negotiations. He's also helped prepared and conducted numerous mediation negotiations for other mediators. And I'm going to let Harry, the chapter of the Miami, our amazing Miami chapter, as our president, he knows Francis Carter more closely, and he has some other things that he would like to share with him, to us.
Thanks, Marcine. I've known Francis for any number of years now. When Francis was an active bankruptcy practitioner, and to his credit, Francis was regarded as the dean of the bankruptcy bar in South Florida, which is quite an accolade because we have a very, very good and have always had a very good bankruptcy and insolvency bar in South Florida. But Francis was recognized as the leading bankruptcy attorney. So we're happy to have him in our chapter. And Francis, take it away.
Thank you, Harry. Harry, it gives me great comfort to see you, because at least I know there's one person on this deal who's older than I am. See, looks can be deceiving, folks. Okay, welcome everyone. I think there's nothing, nothing worse than listening to somebody just drone for an hour. So I'm going to invite you, rather than saving your questions or comments to the end of the presentation, jump in if you have something. Not everything I say is universally agreed to. Okay, most of what I tell you is pretty standard, but some of the things are my opinions, and there are a lot of lawyers around the country and other mediators around the country who take an entirely different view, and I'll maybe identify some of those issues. In any event, why is it important that we have training on this topic of how you represent your clients at a mediation? Well, trial lawyers are highly trained for litigation. That's what they do. At least that's what they're trained to do. But often, surprisingly, skilled trial lawyers don't really understand mediation. And when I say don't understand it, don't understand what makes it work and what makes it fail. And they don't necessarily understand how to get the most out of it. Why is this important? It's important because a little better than 98% of our litigation cases are not resolved by an actual trial. Less than 2% of our litigation cases actually go to trial. So the mediation, your mediation is going to be successful probably more than 70% of the time. Even where it isn't successful at the mediation table on the day of the mediation conference, you're going to have made a start typically, and it'll settle before trial. It'll be based on, starting from the progress that was made at the mediation. Most courts require mediation before trial. It's a hoop you have to jump through in order to get to trial. So I guess my point is it's very important that trial lawyers develop and hone their mediation advocacy skills. It's very important that trial lawyers look at mediation not as just another hoop they have to jump through on the way to trial, but as a case dispositive proceeding, because that's normally what it is. So let's talk about where are we going here. I think the first thing we need to do to represent a client in mediation is talk to the client and ask the client what the client hopes to achieve. Okay, lawyers always assume they know what their client wants, and all too infrequently do they ask. And if they did ask, they might find out something they didn't know, and that would be of great interest to them. So, what are the sorts of things that clients that your clients want? Well, I think the first thing that they want is some form of justice. It may be, usually it's economic justice, or at least economics is the way we fulfill it. Wait a minute here. Sorry, I just lost my screen. There we go. They want some form of justice. I mean, think about it. The clients have an emotional stake in their lawsuit. A plaintiff is so appalled by what he believes the defendant has done that the plaintiff is actually willing to spend good money to hire a lawyer and commence a lawsuit. The defendant is outraged to be served with the complaint, so they're a little wound up from the get-go here, but they want justice. So what forms does that justice take? Well, what's the most obvious thing they want? Jerry Maguire, they show me the money, okay? They want to either receive the maximum amount of money or pay the minimum amount of money. But another thing that your clients want, sometimes desperately want, is closure. Okay, they want to be rid of the expense, delay, uncertainty, anxiety, and distraction from other pursuits. You know, we as lawyers do this for a living. I mean, these cases to us, I mean, we care a lot about our clients, but in a lot of ways, these cases are inventory. They're our livelihood. But to the client, there's a much deeper meaning, and they don't do it for a living, and they don't, for the most part, they don't like litigation. So they want closure. Another thing that, and this is something I recommend to litigators, is an apology. What recommends an apology? Well, for one thing, it may pave the way to a settlement, but the really nice thing about an apology is it doesn't cost anything. A sincere apology is the best, of course, but even a half-baked apology can do some good. I mean, just letting the other side know that, well, you're sorry, you're sorry that they've suffered, or you know, you regret that the matter your company handled for them may have been mishandled. Something where you don't really admit much of anything, but let them know that your heart's in the right place. So an apology can be useful. File that away in the back of your head. It's free. Another thing that your clients may want is termination of a relationship. It could be dissolution of a marriage, a business partnership, a contractual relationship. It could be, this is very rare, but it happens. They may want repair of a relationship. Often a business relationship. I don't know in the marital sphere how often those get repaired because I don't do them. My suspicion is not very often. But it does happen. Sometimes they want vindication of their conduct or their position. Here's one that I think you need to focus on that probably doesn't get enough attention. Your clients want emotional satisfaction. We talked about that at the beginning. Your clients hired you because they wanted to have their day in court. You know, they see all these shows on TV. They grew up on Perry Mason or whatever, or LA Law, or depending on their age. I'm not even sure what the lawyer shows are now. That one from Australia called Rake is really terrific. If none of you have seen it, I highly recommend it to you. RAK, it's a It's a dramedy. Anyway, they want emotional satisfaction. They want their day in court. But as I've indicated, better than 98% of the time, they're not going to get their day in court. So what you can do a lot through simulation and mediation, okay? If you think about it, your client can be heard and understood largely through the opening statement that you're going to make on his behalf. And we'll talk about that in a little bit. Your client can get validation that the mediator and the other side get it. They understand the position, even if they don't go along with any of it, okay? But you need to deal with your client's emotional needs, and you need to help the client discard emotional baggage. So what's our takeaway on client needs? Ask your client what he or she hopes to achieve. Don't assume that you know. Next issue, what should we do when a case is set for mediation? If you're a litigator, what should you do? What do the scouts do? They prepare. Okay? What and how should we prepare? Well, we should prepare a confidential mediation statement for the mediator. But I think it's important to share whatever legal and factual information you're basing your position on. I think you should share that with the other side. I know litigators, they like to keep it very close to their vest. They don't like to share. But if you're going to trial less than 2% of the time, what are you saving it for? Why not get whatever leverage you can from it at the mediation, where it's more likely to be useful than at a trial that's very much unlikely to happen. But in any event, mediation statement's important. Another thing that's important, contact the mediator if the mediator doesn't contact you before the mediation. Because there's a lot of things the mediator needs to know. I've been shocked. Some people say, well, you can't talk to the mediator like that. That's ex-parte contact. No, ex-parte contact with the mediator is an essential part of the mediation process. Your mediator is not a judge. The mediator may be a former judge, but your mediator is definitely not there in the capacity of a judge. And I wish more of the judges who are mediators realized that.
Francis, I wonder if I can interject a comment here.
Please.
I had a tremendous experience in the District Court of Nevada, which I use in mediation. They require mediation with one of the magistrate judges, or at least they did when I was in their court. But they asked that every mediation statement contain the following: the strengths of your case factually, the strengths of the other side's case factually, the weaknesses in your case and the weaknesses in the other side's case. So that's 4. Then the legal strengths of your case, the legal weaknesses, the legal strengths of the other side's case, and the legal weaknesses. Putting it all together, it tells the mediator that you've got a grasp of your case, excuse me, and that you're looking at it objectively. It brings some authenticity and not just a lot of bravado to the mediation process. So thank you for letting me interject that, Francis. Please proceed.
I agree. That what you said sounds really, really good. And there are any number of mediators who ask for that. The problem is lack of candor. What you're going to get back is, my case is 100% wonderful, and their case, and their case sucks. I mean, it's like when in a job interview, when they ask you what your greatest weakness is, what's your greatest weakness? I work too hard. I try too hard, So I think in theory, it's terrific. In practice, I don't think it works. So I think it's laudable in theory, but I don't think it works as well. Let me ask a quick question here. Are all of you litigators, or most of you? How many of you are litigators?
Yes.
Okay, well, I got some. Okay, good. All right.
I got another one here.
And even those of you who aren't litigators are going to need to know something about mediation for your divorce. So it's good to have the training.
Francis, this is Arnie Lutzker in Washington.
Arnie, how are you?
Good. Harry's point raised a question in my mind. I don't know. You may be getting to this later or not, and it's the difference between a mediator, choosing the mediator as a magistrate that is offered by the courts versus private mediation, and sort of an assessment. I don't know whether you were going to sort of get to that later or whether you have any opinion about that.
I wasn't going to get to it, but let me give you a quick comment. One, by and large, I think judges make lousy mediators, okay? They can make good neutral value, but as mediators, no, and the problem is it's a different skill set. Judges are used to deciding things, ruling on things, and telling people what to do, okay? A mediator isn't supposed to be doing any of those things. A mediator is there to help the parties get together, to help the parties negotiate. The danger you have when you have sitting judges sitting as mediators, and this drives me up the wall because in the bankruptcy arena, there are very few judges, and the danger always implicitly, and in some cases explicitly, is don't think I'm not going to tell my buddy judge, whoever he is, who actually is sitting on the case, who's going to decide the case, who I have lunch with 3 times a week. Don't think I'm not going to tell him who the jerk was who screwed up the mediation. And as I say, I am aware that that's been done. It's always implicit, but I'm aware it's actually been done explicitly in some cases. So I'm very much against sitting judges being mediators. And as far as former judges, well, some of them are extraordinarily good mediators. Most of them are not because they just don't have the right mindset. Okay, that's my 2 cents, Arnie. Agree with it or not.
Francis, this is Don Conwell in Tampa. I'm a litigator, and I wondered if you could comment on the timing of the mediation, whether you should push for a mediation early in the case, or whether you ought to wait to the end after the discovery's been taken. And then depending on when you mediate, how does that affect your thoughts on how much to disclose to the other side in your mediation statement? Should you be disclosing something that might be considered your work product, your thoughts and mental impressions about the case, or not?
Great question. Let's go back to the timing issue. In theory, the smartest thing we could do from an strictly economic standpoint would be mediate the case as soon as there's a complaint and an answer. The problem with it is the case isn't ripe for mediation. The problem is at that point in the case, all a lawyer knows is what his or her own client has told them. Okay? So they're in 2 different universes, and their fact pictures barely overlap at all. So each side has a huge valuation for its case and can't understand the other sides. It's only when when the facts develop and the fact picture on each side becomes more congruent or more nearly congruent that you've got enough overlap to settle the case. So my feeling is if you've got a case that's trivial as far as the economic, there's just so little involved, you don't want to spend any legal fees. Yeah, do that one right out of the box, maybe even pre-suit. But if it's a regular sort of case, get the important depositions out of the way, the important document productions out of the way. Get that done, and then from then on, at that point, it would be smart to settle to save some legal fees. But that's something that sometimes the clients want to do more than the lawyers.
Okay.
I'm sorry. And what was the last part of your question? I've lost it here.
Well, does the timing of the mediation, either at the beginning or waiting till the end of the case,
have to do with disclosure?
What you disclose in your mediation statement?
Yeah. No, I don't think you should be disclosing
the other side as opposed to
work product. unless it makes right sense to you to do it. But, certain factual things, I mean, what cases you're relying on? How do you see the facts of the case? You ought to let the other side know where you're coming from, because that's what you base your position on. Okay. But thank you. That's a really good question, Don, and I very much appreciate it. Okay, so where were we? I'll contact the mediator. A lot of important things to talk about with the mediator, okay? You want to know the current status of negotiation, what's the current bid and ask. You want to know whether the case is ripe for mediation, which goes to your question, Don. You want to know if there are any special problems, one of which could be lack of information, conflicting assumptions about facts and law, lack of authority. Is one side unhappy with the corporate representative, say, for the other side who's going to attend the mediation, feeling they don't have sufficient authority? That's something the mediator needs to know about. Is there a need for either participation by or availability of essential non-parties? Because sometimes you can't, without these non-parties, even if they can't be there, they can often be available by phone. I mean, what do I mean by non-parties? It could be an insurance adjuster. It could be a mentor, a spouse, a significant other, an indemnitor, a guarantor. But if these people are important, the mediator needs to know about it. The mediator needs to push to make sure that those non-party essential parties are available. I mean, sometimes say, okay, look, this is going to be a waste of time unless his girlfriend is there. He's not going to do anything without consulting with her or his father or, her brother or whoever it might be. So you need to talk with the mediator before the mediation about issues like that. Another thing you need to prepare, you need to select the right client representative, assuming you have a choice. Sometimes there's no choice, but where you do have a choice, you want someone who's got sufficient authority to settle. You want someone who's got a decent personality for negotiating a settlement. And you want somebody, who's got decent witness quality to maybe show off to the other side. There's a trap here in selecting your representative if you've got a corporate client, though, that you got to watch out for. And that's where the interests of the the client representative are not aligned with the interests of your client. What's a good example? You're defending a corporation accused of fraud, and the representative put forward to you is the main perpetrator of the alleged fraud, okay? You could be in a situation where you're representing the client, the corporation, and the decision maker who is telling you what to do at the mediation is someone whose interests are in conflict with that of your client. That can be very, very uncomfortable for you as a lawyer. So try to sniff that out ahead of time and avoid it if you possibly can. Next thing I'm going to come to is a little more controversial, and that's prepare an opening statement. I am a big believer in opening statements. Around the country and other places, California would be one. They don't, and a lot of places farther west of Florida, they don't do opening statements. They feel it just gets the parties antagonized and emotional, and it's a bad idea. I respect the mediators and the lawyers who feel that way, even though they're dead wrong, okay? I mean, think about it. Those of you who are trial lawyers, you got a case with tough facts. Are you going to waive your opening statement to a jury? Because the jury may be upset by some of the facts of the case. Of course not. This is what they pay you the big bucks for, to make a tactful and persuasive opening statement. The other thing is your client's emotional need. You're their knight in shining armor. You're the person they hired to try their case. And they want their story to be told, and this is where their story gets told in that opening statement. So I'm not saying it is never a appropriate to waive opening statement, but I think it's rarely appropriate to waive opening statement. My personal opinion. Others disagree, and they're wrong. The other thing about your opening statement is, use visual aids if that can enhance your presentation. PowerPoint can be very effective. Handouts of all kinds can be very effective. So keep that in mind. Another thing you have to do to prepare is do a case valuation analysis. And you need to take into account the cost and risk of litigation. You need to if you're a plaintiff, you need to take into account collection issues. Is your defendant going to be collectible at the end of the day? What are the best and worst alternatives to a negotiated settlement? If your case is big enough and there's enough bucks involved, you may want to hire a jury consultant to do a mock trial to evaluate the case. No, I won't tell that story. You want to prepare a flexible negotiating plan, okay? You want to determine, what your client's bottom line is by way of dollars or other consideration, and then how you're going to dole it out in each round of bargaining. It's got to be flexible because obviously the other side is going to surprise you from time to time, but at least have a plan and have thought about these issues. You don't want to bargain emotionally or reactively. I mean, you're a lawyer, you're a professional, and you know better. Last thing I want to say about preparation is prepare and bring to the mediation a fill-in-the-blanks settlement agreement. Why do I say that? Because after a long day of negotiating, it may be hard for you to remember all the things you need to put in a settlement agreement to protect your client, specific things and boilerplate things. And also, if you're the one who brings the draft settlement agreement, you sort of take control of the drafting process, which is an advantage to you and your client. So what is our takeaway on preparation? Prepare for a case dispositive proceeding, okay? Because that's what the mediation is going to be many, many, many more times than an actual trial. I want to digress for a minute here to who should you speak to in your opening. We talked about the opening statement. The reason I say this, lawyers get confused and think it's a chambers conference. They're sitting at a table and the parties are on both sides and the mediator is sitting where the judge sits. So whoever's making an opening will turn to the mediator and talk to the mediator. Well, that's great, but the mediator doesn't have the power to decide anything. Okay? You want to talk, you want to talk to the opposing party, and not just the opposing party, the decision maker for the opposing party. If you talk to their lawyers, they're sitting there making notes and listening to everything you say, but the notes they're writing are all rebuttal. Okay, talk to the decision maker. Do it tactfully. You're there to make peace, but get across that you have confidence in the strength and viability of your case, but that you want to settle, and that you're willing to have a reasonable settlement, whatever that might mean. So you need to set the right tone with your opening statement and speak to the right person, and the right person, your takeaway, the right person, speak to the client decision maker on the other side of the table. We talked about having a negotiating plan. With respect to a negotiating plan, excuse me, what's the greatest fear a negotiating party has, and how do you deal with it? The greatest fear is of leaving something on the table, of not getting the best deal that you could have gotten. Okay? People are concerned about that. So how do you get across to them? How do you negotiate in such a way that when you tell them an offer is your final offer, that'll be credible? The method that I'm aware of that works for this, and for whatever reason, I get a lot of pushback on this and not many people adopt it, but I believe in it and I feel duty bound to tell you about it anyway, is called tapered concessions. Okay, is that a term that's familiar to anyone? Well, it is what it sounds like. Okay, the biggest move you're going to make should be the first move you make. Every move you make after that should be smaller than the last move you made. So what does that do? It consistently points toward where you want to be at the end of the day. And it makes it more credible. The problem you have is people do what I call, yo-yoing. They make big moves, they make small moves, almost at random. Consequently, when you get to the end of the day, people are wondering, well, gee, maybe there's one more big move left. So I say you want to be consistent. You want to have a negotiating plan that points to where you want to wind up. Okay. Also on tapered concessions, even if you don't go along with it, and a lot of people don't. I've never heard a good articulation why, but a lot of people don't. As you get to the end of the day, as you're getting to the last rounds of negotiation, you've got to taper your concessions, and you've got to tell the mediator, let them know there's not much more gas in the tank. Okay. Otherwise, you just drop the mediation off a cliff. The worst thing you can do to a mediator, you're going along. Each side's making offers, counter offers, further offers, counter offers. They're going back and forth. One side makes an offer, the mediator takes it, comes back, says, well, they rejected that offer, but they've improved their previous offer. They say, oh, no, that was our last offer. What do you mean that was your last offer? Well, that was our last offer. We're going home. Well, why didn't you tell me it was your last offer? I know, but it was our last offer. You just, it really makes a mess. You got to let them know. And again, this is part of your credibility, that your last offer is your last offer. Is let them know that that you don't have much left to give them. It would seem. I hope that makes sense to you. So our takeaway here is have a negotiating plan that points to where you want to wind up. It's ironic to me at mediations, people want the other side to come to their number. Just to make it a simple money negotiation. They want the other side to get their number, but they don't want to do anything to give away what that number is and where they want the other side to go. And the problem is when you keep the other side in the dark about what it is that you want, when you keep them in the dark, they're going to take very small steps. Okay.
Francis, Jane had a question.
Oh, I'm sorry, Jane. Yes, you're on the edge of my screen, Jane. So you can just shout out if you
Okay.
Please go ahead.
So the issue I have with tapered offers is that you're not negotiating in a vacuum. You, to a degree, have to react to what the other side is doing. And if they're taking baby steps in the beginning, I'm not putting all of what I've got on the table or making a substantial offer until they look like they're serious people.
Well, I'll tell you how I handle
Sorry,
that.
I've got a whiny dog. I'm going to mute. Sorry.
Well, I've been called worse, Jay. I urge the part. One of the things I like about tapered concessions, you make your biggest move first. It starts the mediation off in a good way, gives you something you can build some momentum on. Okay. What I urge parties to do is make a decent move. Your first move, make a decent move. If you get back a crummy little move, make a second decent move, though smaller than the first one. No, wait, follow me before you reject me. If you reject me, then okay. Make a second decent move. Tell the mediator to go back to them and say, look, we're here in good faith. We're not making another move unless you move to or in excess of some number that where you think they ought to be. And I would set that number maybe 125% of where you want them to be. Okay. That way, you haven't really hurt yourself. If they still want to make baby steps and you're making decent moves, okay, well then you're not going to get it done. But often that, gets them back onto the playing field, so to speak.
But if it doesn't, you've just lowered or raised your bar for the next round of negotiation. I'm sorry, it's very loud here. And you've given away a lot of money to a party that's not shown any good faith in response to your
Well,
initial.
I said a lot of people don't believe in doing it that way, and I understand. But for God's sakes, when you're getting near the end of the road, you really need to do this. Okay. Thank you, Jane. Okay, now we come to the part of the presentation that I think is the most fun, and this is what mistakes do lawyers make in mediation. The handout that's been provided to you has got 32 of them. When I started doing this presentation some years ago, I had maybe 5 or 6 on the list, and it's just grown like Topsy, and I think there's no end in sight. Okay, some of these will be obvious, some of them maybe not so much. The first one, Don, you'll get a kick out of this. The first one is mediating before the case is ripe for settlement. Okay, when all the lawyers know is what their own clients have told them. Second one, which I hope is self-evident, failing to treat the mediation as a case dispositive proceeding and to prepare accordingly. Okay. The next two go together. One of them is negotiating against an empty chair, and the next one is negotiating against an empty suit. What do I mean by that? An empty chair means that the client representative is not present and participating. For one side is not present and participating in the mediation. I tell people, don't be sucker punched by civility. I mean, back when we were doing the sit-down mediations before we were doing them on video with the pandemic, I thought, well, you don't want to make my client fly in all the way from Chicago to Miami, do you? He can be on the phone in Chicago. Well, no, you don't want to go along with that because you don't get the same buy-in, and it's just harder for the mediator to have an effect on somebody on a telephone call than it is sitting there face to face. The video is better for that sort of thing. So the other thing, that's an empty suit, the party that's not present. An empty.
Can I ask a question about that? To what extent?
That's an empty chair. Yeah, let me give me half a second. I'll let you ask questions. The other one is the empty suit, and that's someone who's present but doesn't have sufficient authority. Go ahead, Don.
Francis, I wanted to know to what extent COVID has affected the success rate in settling cases through mediation, either because maybe the defendant knows they don't have to face a jury for who knows when, or because they're not required to leave their own office. They don't have anything at stake in terms of a trip, as you just mentioned. Have you found that affects the success rate?
I have not. I find the success rate is about the same, but I've heard a lot of people complain that it does. I think if you're dealing with really huge, complex cases, it probably does. But for your normal run-of-the-mill civil commercial cases, let me tell you what my average case, and I do smaller ones, a lot of smaller ones, and some bigger ones. But my typical case is a case where, say, a plaintiff is suing for a couple $1 million. The real value of the case is probably somewhere between $250,000 and $750,000. At the point where they get to the mediation, they've done their discovery and such, or most of it. At that point, each side has run up 6 figures of legal fees. Okay, and the truth of the matter is, anywhere in that range between $250,000 and $750,000 is probably a win-win, given the risk and additional expense to go to trial and post-trial factors. So it's time for those to get settled, to stop the fee meter from running. And also, you got a lot of younger lawyers out there who, unlike some of us of an older generation, don't get the kind of court experience and trial experience that we got. They don't get to go to court as much, and they're litigators rather than trial lawyers. They spend all their time doing, discovery and motion practice and getting cases ready for trial, but they're scared to death of actually having to try them. So I find that the settlement rate hasn't suffered very much by reason of video. In fact, I'm going to try, when the pandemic is over, I'm going to try to keep convincing people to do mediations with me by video, because I really like them. So you ask a short question, get a long answer. There's a lesson.
Oh, thank you. That was helpful.
In any event, when we're talking about negotiating with an empty chair, someone who's not there, an empty suit, someone who's there but without authority, what you're really doing is you're allowing your opposing counsel to immunize their client from the influence of the mediation process and from the influence of the mediator. So don't go along with it, especially, and don't be suckered into thinking that civility requires that you go along with it. It doesn't. If you've got a problem like that, see if you can ferret it out ahead of time and let the mediator know if you're not satisfied with the quality or authority of the participation on the other side. Selecting the wrong client representative, we've talked about that. Failing to secure the participation of or availability of a non-party necessary to reach a settlement, okay? Don't underestimate the effect that an essential non-party can have on the success of a mediation. Because if they're truly an essential non-party, you're just not gonna get anywhere. So bear that in mind. Let the mediator know if the mediator needs to press the other side to make sure that the non-party is available. Treating the mediator as an adversary rather than as a helpful resource. Okay, I mean, I don't get this too often. I think partly because a lot of the lawyers I mediate with are lawyers I know and that I've known for a long time. But for whatever reason, some lawyers like to treat the mediator as the enemy, and you're paying the mediator to be helpful to you, and if you let the mediator can be helpful to you. We'll talk about how in a little while. Waiving opening statement, I've talked about that. I think it's a bad idea, but I've said enough on it. Here's one that not just for the lawyers, but for the clients as well, and that is becoming impatient. That's a big mistake. Mediation is a process. It's a dance. Don't be put off, Jane. Don't be put off by an insulting first offer, okay? You got to start somewhere.
Francis, I have a question.
Yes.
How do you make your mediator your negotiator?
How do you
make your mediator your negotiator? How can you get the mediator off his neutral horse to be your negotiator?
Well, I think the problem is much of the time, once the mediator appears to be an advocate for the other side, the mediator has lost one side of the deal. I never come in and say, I shouldn't say never. I mean, there's sometimes when they're just so far off base, and I do know the area of the law that I just got to tell them. But most of the time I say, look, Harry in the other room has told me to die and to die and to die, and he's got the cases to back it up, and he's basing it on these facts, and he's just not going to give you any more money until you tell him how you're going to overcome those issues. Okay, now I presented it. I hope I presented it forcefully, but I haven't said Carter is telling you that you got to do this. I'm saying, Harry's the guy you got to convince. He's the guy whose client has the checkbook. So, I mean, I think it's how you do it. But once you lose the appearance of neutrality, you've made a mess of the mediation, in my view.
Thank you.
Let's see, where were we here? Yeah, becoming impatient. And as I say, I have a concept I call ass power, which is the ability to just sit there in your chair and negotiate for as long as it takes, okay, until you get it done. There's a big benefit from that. And a related issue, a related thing that I think lawyers get wrong is they quit too early. You don't want to be the first to quit, okay? Why do I say that? Because even if you realize that you're not going to reach a settlement at this mediation, you want to stay there long enough to determine what the other side's bottom line is if you can. That's very useful information. Because remember, you're probably going to be settling the case before trial anyway. Another mistake I see, and I see this all the time, is lawyers come to the mediation to try their case before the mediator rather than to negotiate a settlement with the other side, okay? It's a different mindset, it's a different skill set, it's a different way of presenting and thinking. Believing you are there to punish or vanquish the other side, and believe it or not, people show up with that attitude. Here's one that I think, this is one that I think is really important, okay? Falling in love with your own valuation of the case. A lot of times you're not going to get it right. Even when you do get it right, the trial judge may get it wrong, the jury may get it wrong, the appellate court may get it wrong, okay? The point is, you get to evaluate your case. You get to put a value on it, but you don't get to decide your case. Somebody else is going to do that, okay? So yeah, your value, I mean, you've got to have a touchstone. You've got to have some idea what you're working with, but don't actually fall in love with your valuation of your case. This sounds crazy that I even have to mention it, but another mistake that some lawyers will try to make is making well, a lot of times it's client driven too, making your best offer your first offer. No one ever believes you. Okay, even if it's true, even if this is your first offer is your best offer, no one will ever believe you. So consequently, you should, if you want to make a deal, you should never present it that way. A similar error is believing that bargaining needs to be symmetrical. That is, that in each round, the other side should make a concession at least equal to the concession that you made, and that overall the concession should be equal. In the real world, it just doesn't happen that way, and that the moves from round to round and the overall result are generally bear a rough relationship to the relative strength of each case, okay? So, you know, they're not going to make moves equal to yours unless if you've got a stronger case, and then you want to see them make bigger moves than yours. Is everyone here familiar with the term bracket move? Do you know what a bracket move is? It's we'll come up to X if you come down to Y. Okay. The thing is, bracket moves can be very, very useful, but you don't want to do it too early. If you do it too early, when the gap is too wide, you can just throw the thing into chaos, okay? That's something you need to talk to the mediator about, or the mediator may propose it to you. Bracket moves at the right time are good for accelerating the bargaining and getting to a mutually acceptable result. But you got to do them at the right time. One we've already talked about here: failing to advise the mediator and the other side that you are nearing your final offer. As I say, by tapering your concessions and having the mediator tell them, look, they're telling me they don't have much room left. Here's one that isn't obvious, okay? But I have a lot of faith in this one. Offering to split the difference. Happens all the time, doesn't it? Invariably, do they say, yeah, okay, we'll split the difference? No, they say, no, let's split the remaining difference. Okay, that's why you don't want to do it. If you want to split the difference, I think the proper way to do it is you say to the mediator, okay, here's what we're going to do. You know, we're $10,000 apart. tell them we're not going to make another move. But if they come up $5,000, we will accept it. Now they can't screw around with you, because if they only want to, they only want to come up 2,500, well, you just come down 2,500. But the point is, you don't let them get ahead of you. But that's the way to split the difference. But don't ever say, and unless you're $2 apart or something, don't ever say, let's split the difference. It usually just doesn't work. Making backward moves. This is, you usually run into this at the beginning. That there's been an offer outstanding. They say, well, that offer is off the table. Since we made you that offer and you didn't accept it, we've incurred additional legal fees. Well, so is the other side. That's a neutral thing. You can't put the toothpaste back in the tube. Don't move backwards. If you've offered it, stick with it, unless there's a really good reason not to. Here's one that I think is really really important. If you're representing a defendant and the defendant's got financial issues, okay, failing to provide credible documentary evidence of a defendant's uncollectability. And the failure, I'm going to tell you, the failure to provide that credible documentary evidence of uncollectability gives rise to a very strong inference that your client is collectible. So please keep that in mind. Ultimatums are a bad idea. They paint you into a corner, so use them very sparingly. Here's one that I've seen on a couple of occasions: suggesting in front of an adverse party that its lawyer cut their fees in aid of a settlement. That does not go over very well. Another one here, failing to have a transactional lawyer available to you if it's a complex case, to help you either draft a settlement agreement or to give you tax advice. There are times, I mention that here because with big firms, it's easier. With this group, where you're dealing with smaller firms, you may need to affiliate somebody in an appropriate case to help you with that. There were a few other things in there, but I'm going to leave them and go to the last issue because I see our time is running a little short. But what's our takeaway from the mistakes lawyers make at mediation? There are innumerable mistakes that lawyers make in mediation. Avoid them. Our final topic here is, how can a mediator help you reach a settlement? Okay. I think the first thing a mediator can do is engage and empower the parties. In other words, make the parties participants, not just spectators. Make sure they understand it's their mediation and that, guided by their counsel, they have the opportunity to play a leading role. After all, it is their money and their interest. Another thing that the mediator can do is help the parties overcome reactive devaluation and attribution bias. What does all that mean? What that means is parties who are in an adversary relationship tend to view anything the other party says or does in the worst possible light. The mediator needs to provide a reality check and say, no, this is what's really meant and intended. You're straining things too far. Another thing the mediator can do is moderate the bargaining, reframe issues and comments, provide a reasonable interpretation as to the meaning and intent of offers and positions. Help the parties communicate with one another. Well, of course, when you've got the parties in caucus rooms, the mediator is the communication link. Moderate emotional issues, help the parties make rational business decisions. What you have to do as a mediator, the parties start off with, she done me wrong, he done me wrong. You've got to transition them to looking at it as, no, this isn't a personal thing. This is a business dispute. It has a business solution. If you can get them to look at it like that, you're well on your way to a resolution, especially if you're dealing with money. You need to remind the parties that they only need to agree on the terms of the settlement. They don't have to agree on anything else. They don't have to change their view on anything else. as a mediator, you need to take the imaginary option, which is you get everything you want. You need to take that off the table. And you need to help the parties determine which options are in their best interest and to get them to choose the best from what is often an array of horrible options. Yes, ma'am. Marcine.
A question, and I'm not a litigator, and I don't go to mediation, but I really enjoyed this presentation. But I had a question that I think is, so if I were looking for a mediator, or anybody in this room as a litigator, we're looking for a mediator, would it be wise for us to, if you could choose the mediator and you weren't appointed a certain person, would it be a good idea to get to know who the mediator is and what is their style? Because it seems like if I was going to be before you and I knew it, I would want to do the things that I know that you like, and it would be helpful for you to mediate the case. Do people do that? And is that a good idea for you to just, like, if possible, find out what the needs and wants are of the mediator?
Well, people get to know mediators by using them and by their reputation. I've said that I'll tell you one, for example, if you have a strong case, if you feel you have a really strong case, you are well advised. The parties, I should say, let me back up. The parties have to agree on a mediator, okay? If they can't agree, they'll get one off a wheel at the court, and they're probably better off to agree. And if you have a really strong case, you should be more likely to go along with the mediator that the other side wants. Because if you've got a strong case, you want somebody that they trust who can talk to them and who can persuade them, okay? I think there are other situations. I think if you're dealing with an insurance carrier, I'm not crazy about former judges, though I said there are some exceptions who are really, really good. But in some cases, I think if you're dealing with an insurance adjuster, having a former judge there may give that insurance adjuster cover to put more on the table because, well, Judge so-and-so who's experienced these cases said that, we were offering too little, that sort of thing. But yeah, to the extent you get to know your mediator, you know your mediator's style, and you may want a mediator who's familiar with the subject matter as well, who practiced in that area. Though frankly, that's a little overrated. I mean, 80% of it is just dealing with the people, dealing with hurt feelings. But it's a good question, Marcine.
Great, thanks. I see
Okay,
we're running
let me just sprint to the end of
this.
this.
Yeah, I'll let you sprint to the end, and then we'll close.
Okay. Anyway, you have to help the lawyers and the mediator have to get the parties to choose from what are often a dismal array of options, but still one will be better than the others. And you want to try to get them to understand and appreciate and embrace that option. I don't like to provide legal advice as a mediator. I mean, that's what you folks are for. The parties hired a lawyer, and it's their turf. But I do provide negotiating advice as to the form and amount and timing of offers. And in that regard, I'll help the parties recognize, for example, non-monetary issues, non-economic issues, or what I call asymmetrical, well, not just what I call, what's called asymmetrical consideration. Is that a term that's familiar to you? All it means is asymmetrical consideration. It means that a party receiving a benefit puts a greater value on that benefit than the cost to the party conferring the benefit. And you make the parties aware of these things, the asymmetrical consideration. Look, you can give them something that doesn't cost you much and they really will value it highly, or the non-monetary issues or the non-economic issues. And that way you can help the parties, the mediator can help the parties make offers that are more attractive to the other side. Help you understand the other side's case and the other side's point of view and what their needs are. And finally, the mediator can tell, if you ask the mediator to do it. I mean, I never want to show up a lawyer in front of the lawyer's client. If I think, the lawyer's got something wrong, that's, none of my business. But if the lawyer comes to me and says, look, I can't convince the client, this point, just won't give it up. Would you talk to him? And then I'll go up. Okay, yeah. Anyway, the takeaway here is to recognize and use your mediator as a valuable. Folks, that's all I got. But if you have any more questions, I'm here to answer them. And if you've had enough, if you've had quite enough, I can certainly understand it.
No, it was a terrific presentation, Larry. I mean, Arnie, did you want to do the close or ask a question? I see you.
Well, I don't know whether I'd be opening up too many issues, but in two things: difference between mediation and arbitration, binding and sort of not, in terms of ways to go, and the complexity of cases when you have a really complex case. How well is mediation an option?
Well, I mean, the difference between arbitration and mediation have pretty much nothing in common. I mean, arbitration is just streamlined. It's just a streamlined trial, is it not? I mean, the point is, in arbitration, you give up the right to decide the case to a third party. In mediation, the parties don't give up the right to decide the case. They have to agree. The mediator decides nothing. In some states, though, they have what I call mediation with teeth. I mean, Michigan is one of them. In some states, if the parties can't agree, if it comes to an impasse, the mediator proposes a result that the mediator thinks is fair to the parties. If the parties reject it, or if a party rejects it, and at trial that party doesn't do as well as that party would have done had the party accepted the mediator's proposal, that party pays the other side's legal fees. So I understand in Michigan nothing goes to trial anymore. I'm sorry, was there a further part of your question, Arnie?
Well, in terms of the complexity, the utility of mediation.
Oh, yeah. I don't think complexity matters that much, because mediation is still valuable, because you can, even if you can't settle all the issues, you can narrow the issues. In fact, one result that you can get from a mediation in a big enough case is you can get the parties to agree on a high-low. Even though they're going to a jury, you can get them to agree on a high-low that'll limit what the jury does in either direction. I mean, that is one possible result from a mediation. But, you know, in a lot of ways, I mean, think about mediation. You know, if you're in arbitration or litigation, a lot of the legal issues have to be resolved. In mediation, they're just pricing issues.
Francis,
yes, Jane.
Jane, let me, one quick question. Have you ever done any FINRA securities arbitration mediations?
No, I have not. That's people have special training for that, and that's kind of a closed, you know, there's a group of people who do that. It's very lucrative, is the upside. The downside is you're on a plane every week going somewhere to do one of those, or at least you were before video. But I don't do FINRA. Okay, thanks. Go ahead, Jane.
Do you have any suggestion for how to lock the parties into the settlement when they're second thoughts a day or two later? I've had to litigate to enforce the settlement based on a term sheet of the parties.
Oh, Jane, what a wonderful question. I think, you know, as a mediator, you have to pretend you're a car dealer. You just don't let them out of the showroom until they've signed off, and that's the problem. That's the problem. It was a lot easier before the video. You know, in the video now, a lot of them just, oh yeah, okay. What I do at a minimum, I get them to sign a sheet of bullet points, and if I can get them to, I'll get them to say, look, this is meant to be binding, and this will be replaced by a plenary settlement agreement that contains all the such reasonable and customary provisions as go into settlement agreements of this type or something like that. But you got to get them to sign off on something while they're there, because you know you can't let them you can't create the opportunity for them to get buyer's remorse, and that's absolutely essential, Jane.
I had a case where the parties signed
which is why I suggested earlier that you take a fill-in-the-blank settlement agreement with you to the mediation? Go ahead.
We had signed exactly what you just described. It was a term sheet that said subject to a full and complete settlement agreement. And the other side, realizing the settlement was taxable over the weekend, tried to back out on Monday. And what's the only thing that saved us, the court said it was conditioned on this overall settlement agreement, but what saved us was that an email to the mediator the following week, before she realized what happened, she confirmed, yes, we have a deal. And that's why the court enforced the agreement. So you always have to have an overall settlement agreement. And I've always struggled with how to make it as bulletproof as possible, but still allow for the fact that you're going to have a more comprehensive thing. And I'm looking at Dave, who is your counterpart here in New York, and I'm thinking he has some thoughts on this too.
You think right. I'm David Abe's house. I'm in New York.
We've met.
Yes, once or twice. I'm in New York with Jane. Although not in the same place, unfortunately, because I like being in the same room as Jane. I'm a longtime arbitrator and mediator and a trainer of arbitrators and mediators. One of the things that, I'm sorry?
You're what of?
A trainer.
Oh, trainer, okay.
I train new and advanced arbitrators and mediators on behalf of the New York State Bar Association. And one of the things that we do emphasize in the trainings, and actually, believe it or not, also in my practice, is when I get there, the first thing that I do with my mediator's opening statement, one of the first things I say is, I'm ready, willing, and able to be here as long as you are. And that may mean, in some circumstances, going on into the night, and it has happened that way. And one of the reasons I set the stage that way is to hold parties' feet to the fire. I also do tell them during, as Francis referred to, it's crazy if the mediator doesn't contact the parties, meaning the lawyers, beforehand. But as Francis said, if your mediator doesn't contact you, you should certainly contact him or her. But when I contact them and have pre-mediation sessions, which certainly can be separate with each side or collective, there's no problem with ex parte communications, as Francis said. To tell them exactly what he said. Bring a skeletal outline, and nowadays with laptops and everything, it's easy to finish up a document, and that way you don't have that issue of having to follow up another day. Because if you look in the court, if you do some little bit of court decision research, you'll see the court's decisions are legion about what constitutes a binding settlement agreement. And a lot of those come out of mediations, and sometimes it's binding and sometimes it isn't. So you've got to be very careful about that. And I think the best way to do it is not walk out until you have a settlement agreement. Sometimes it can take to the end of the day or a second day or a third day, depending on the complexity of the case, which goes back to Arnie's question. Yeah, I mean, very complex cases are completely suitable for mediation. Sometimes, I'll differ a little with Francis here on whether subject matter expertise is helpful. I know, Arnie, you're in a technical area of the law that your general practitioner mediator may not have as much of a bead on, and may not be as helpful to you in caucus or in general session, if that's the way the mediation is being run, if the mediator doesn't have an understanding of the technicalities of the substantive area of law. And one final thing before I shut up. See, Jane, you should not have started this. I want to go back to Harry Payton's question about how to make the mediator negotiate for you. And Francis was completely correct that once the mediator loses his or her neutrality, they're done for. And that's what happens when, for example, they make a mediator's proposal at the end or so on. But one simple way to make the mediator negotiate for you is if it is the kind of mediation in which you're having a caucus, and a general session and caucus and so on, and the mediator is playing a little bit of shuttle diplomacy, going back from one room to the next. One simple way to have the mediator have him or her make your proposal for you, presenting it as his or her own. In other words, in caucus, You've talked to the media and say, look, we want to say this, but we know that there's going to be, that kind of reactive response that Francis talked about before, reactive deduction. Anything that I say as a party is going to be devalued by the other side. And
Right.
so I think it's much better coming from Francis, because everything I say is nonsense in the eyes of the other side. So that's one way you can make the mediator your own, by having him or her make your proposal for you when they shuttle over to the next caucus. I'm done.
Hey, David, thank you. That's a tremendous bit of advice. Thank you very much.
I'm curious, Dave. I find that when a party tells me this is our final offer,
Mhm.
It usually means they've got probably 2 more offers left.
I always say, yep, that's your final offer, except if it isn't.
Well, but so I take it to the other room. I say, and they say, and they said it's their final offer. Well, is it their final offer? So I said, well, they said it's their final offer.
Right. Exactly. Right. Well, I mean, that's a very good point. But what I was talking about to Harry was the broader question of just how to use the mediator as a tool, and that's what we are as mediators. Used both, as Francis said, for and how to make an offer, when to make an offer, how to couch it, how to strategize the series of offers, whether you're tapering or not, but also using them as your negotiating tool.
Mm-hmm.
Wow.
And if I can add something to what you said, Dave, about the value of the of speaking with the lawyers before the mediation. In a lot of these cases, I don't know either one or both of these lawyers. I've never dealt with them before. I've never even met them before. So it gives me a chance to get to know them a little, to build some rapport with them. So we're not starting from stone cold at the mediation conference itself.
Wow,
Right.
that's
Marcine, you had something?
Everyone, oh no, I just think that we're a little bit over time, and this is such an engaging webinar that everyone has so many questions. We usually try to keep these to an hour, but we're a little bit over an hour and 15. If anyone doesn't have any other pressing questions, why don't we close this webinar? If you have questions, Francis, would you be open to people emailing you? And
you're an old guy. What do I have to do all day long? Except mediation.
Mediation, right, exactly. So if you have any other questions, please email them to Francis. He says he's open for them in between his mediations. And yes, and we will be back again on the 13th of January, I believe. And Annabelle will send out the new schedule for our next webinar. Thank you, Francis, so much.
I want to thank you for having me, and thank everyone for their kindness and attention.
Marcine, if I could just add one additional comment, I want to thank both Francis and Harry for bringing Francis into the network. I think this has been one of the most enlightening, engaging webinars, and I think, Francis, hopefully your legend will expand within the network in the coming months. Thank you.
Good pick, Harry. I agree. Good pick.
Right. Thank you, everyone.